she's ready. Okay, well, thanks for coming. I'm very glad that the Duke Law Journal does this lecture. I think it's really important for all of you to engage with the scholarship in the journal, not just on a footnote by footnote level, but also more conceptually. And I think you made an excellent choice in who you've decided to bring in. One of the unsettling things about law school is that for most of us, it's an occasion when we find out that there are people in the world that are smarter than we are. Sam Bagenstos is one of the people I discovered that was smarter than I am. He was first in his class, first in my class at Harvard Law School. He clerked for Judge Stephen Reinhardt on the Ninth Circuit and for Justice Ruth Bader Ginsburg at the Supreme Court. He practiced law for the Civil Rights Division of the Justice Department, and he is probably the dominant scholar of his generation on the subject of the Americans with Disabilities Act, as well as an extremely important scholar in constitutional law. If anyone can figure out the mysteries of the spending clause and the unconstitutional conditions doctrine, which I have never had the guts to try, that would be Sam. I'm particularly glad to be able to share him with you, because I think he's also, at the age of 40-ish, already an example. I know, don't gloat. He's already an example of a life well lived in the law. He has managed to be an extraordinary student, a dedicated public servant, a first-rate scholar and teacher, one of the best appellate advocates of his generation. He argued 2 cases in different courts of appeals last week alone, and an outstanding husband, father, and friend. If you're trying to figure out what you want to be when you grow up, what you want to be like, you could do worse than to look here. The only bad things I can say about him are that, as a graduate of UNC, he tends to root the wrong way in ACC hoops matters. He has an unfortunate tendency to taunt me and make snide comments when the Redskins beat the Cowboys. Fortunately, that's unlikely to happen again. I'd like to thank the Duke Law Journal very much for inviting him here, and thanks, Sam, for coming.
Well, gosh, thanks, Ernie, for that introduction. I could say all of the same nice things and many more about Ernie. Certainly, as someone who I look up to as an example of the kind of person who I would like to be. If I could be, and I am not yet 40, I'm 38, and I just want to, it's very important to me at this stage of my life, actually, that I'm 38. That I'm not 40. He also took all my jokes. So I mean, the one thing I will say about Ernie is it's actually great that I can have a friendship with someone with whom I disagree about so many things, such as the Tar Heels and what's the team here? I don't know. The guy, Krzyzewski, I don't like him, but and not to mention to have the experience of watching the debate with him last night was great fun. And I'm really thankful to the folks at the Duke Law Journal for inviting me here. I think that this is a great tradition to have. When I was in law school, we didn't have this tradition of having people who wrote for the Law Journal actually come and talk about their work. I think you probably could have chosen better this year, but at the very least, it's nice to have the tradition going on. The paper that I'm publishing, which is coming out maybe next month, I guess, in the journal, is about the spending clause. It comes from basically my experience over the last 15 years since I graduated law school and instantly began spending much of my time defending the constitutionality of federal civil rights legislation, in an era when the Supreme Court was beginning, for the first time in a long time, to impose limitations on Congress's power to adopt legislation like civil rights laws. So I started working at the Civil Rights Division in 1994. In the wake of New York versus United States, which was the anti-commandeering case, and immediately was defending the motor voter law, which commandeers the states, but we convinced many courts that it properly commandeered the states, and that was okay. And then in the wake of United States versus Lopez and City of Bernie versus Flores, limiting Congress's power under the Commerce Power and Section 5 of the 14th Amendment, it became exceptionally important for civil rights laws that Congress's spending power, remain a way to regulate the states and authorize lawsuits against the states. Because while the Supreme Court mostly in its decisions striking down civil rights laws in the late 90s and early 2000s, didn't strike them down entirely, but struck down their provisions for money damages. The only way that civil rights laws get enforced is if there's some lawyer out there who has an incentive to bring the suit, which means there has to be money damages, the availability of money damages that they could get a contingent fee from, a third of, or 40% of, or whatever. And so this issue became very important, and the genesis of this paper is in 2000 and maybe two. I remember having conversations with people who said, oh no, we're losing from people who litigate on my side of civil rights cases, oh no, we're losing the 14th Amendment, we're losing the Commerce Clause, the spending clause is all we've got. Congress has attached civil rights requirements to various federal spending legislation. There are very important cross-cutting statutes saying any time a state accepts federal funds, it has to agree in any of its programs not to discriminate on the basis of race, on the basis of sex and educational programs, or on the basis of disability. And that these looked like the last line of defense for civil rights lawyers. And I remember saying at the time to people, oh, no, no, no. Don't you worry, the spending clause is going to be just fine. And in fact, maybe we'll win some of these other cases. I remember also at the same time various lawyers who take a more pro-states position than I tend to take, saying, the spending clause is the next place where the court really is going to limit federal power. The spending clause is what Congress is going to, and the Supreme Court wants its decisions to stick. If they say you can't do something under the Commerce Power, or you can't do something under the 14th Amendment, well then certainly they're going to say you can't do that same thing under the spending power. And I remember saying to those people, you're crazy. And so this paper sort of arose from that. Not specifically about civil rights legislation, but about Congress's conditional spending authority, which has been seen as the way that Congress can do whatever it wants to do. After the Supreme Court said that the Hamiltonian position rather than the Madisonian position wins and is the position that guides our interpretation of Congress's spending power. It has been understood that Congress can spend for whatever purpose it wants, and Congress can attach conditions to federal spending for whatever reason it wants, subject to very limited exceptions, which I'm going to spend some time talking about. And I think these limited exceptions basically are non-existent, or at least as a practical matter can't be expected to exist in any significant way. Great fight in the early republic over what Congress's spending power means, right? The Hamiltonian versus Madisonian position I talked about. What Madison said, he often took the sides of states after advocating the Constitution and its great grant of federal power to the federal government. He then immediately started saying, well, the states have these rights and the states have these rights and they've retained all these rights. He began to take the pro-state position, and he said, well, if you look at Congress's power to spend, it's only a power to spend in aid of the other federal powers. It doesn't expand Congress's powers. Hamilton said, no, why would there be a specific spending power in the Constitution, in the so-called General Welfare Clause, pay the debts of the United States, provide for the general welfare, if it didn't mean that Congress could spend for reasons outside of the enumerated powers in the Constitution. And in the New Deal period, the first set of New Deal cases, United States versus Butler, which struck down President Roosevelt's Agricultural Adjustment Act, the first AAA, what the court said is, well, actually, we agree with Hamilton, but then issued a ruling that seemed to agree with Madison. But the black letter law ever since then has been, and after Butler, not just the black letter, but also the practice has been, that Congress can spend for whatever purpose it wants, whether inside or outside of its other enumerated powers. This is an extra power. This is why people who want to limit federal power are so scared of the spending power. But I want to argue, and I do argue in the piece, that Congress's spending power is not really going to be limited in any significant way. And I think that for two basic reasons. One has to do with the analytics of the various doctrines that have been proposed or conceived of to limit Congress's spending power. And the second has to do with the motivation of the courts. The motivation of what I say is a conservative court, a conservative Supreme Court, and relatively conservative federal judiciary. There's a lot of expectation that conservative courts are going to want to limit federal power in every way, and I argue in the piece that's actually wrong. There are lots of reasons why they're going to like federal power in various cases and not going to want to limit it. So let me talk a little bit about the analytics of the doctrines, and then I'll talk about the motivations. What my argument in the piece is that the three basic doctrines that have been understood as possible limits on the spending power are doctrines that have not in the past and cannot be expected in the future to impose any real limits. Those are the doctrines of general welfare. Congress has to spend for the general welfare. The doctrine of nexus, relatedness, germaneness, right? Very familiar concept in law school. You get that concept in lots of different areas of the law. The idea that the spending condition, when Congress attaches conditions to federal spending, has to be somehow related to the purpose of the spending. And then the limitation of coercion. Congress can't coerce the states into accepting, right? This is actually the limitation in U.S. v. Butler that the court enforces, but hasn't really been enforced since then. And what I want to say is, if you're sitting in the Supreme Court as a member of the majority of the Roberts Court, or you're sitting on the federal courts of appeals as a conservative judge, you are not going to find any effective way to give force to those three doctrines. General welfare, take the first one. Well, Chief Justice Rehnquist said that, well, the doctrine of the general welfare is one on which we have to give great deference to the Congress. Obviously, Congress makes a determination, it's passing a law that it's in the general welfare, and who are we to second guess, right? This is modern conservative judges as one of the heirs of the New Deal settlement, right? The sort of Bekelian side of the New Deal settlement, the idea that the courts shouldn't be second-guessing policy judgments of Congress, shouldn't be second-guessing policy judgments of legislatures, right? And what Rehnquist said is, well, certainly we have to pretty much defer almost entirely. As a practical matter, the courts have deferred entirely to Congress's understanding of the general welfare. There are proposals, I talk about in the article, there are proposals to invigorate the general welfare doctrine. John Eastman, the dean at the Chapman University Law School, a very fine constitutional scholar, very conservative constitutional scholar, says actually the place to look for a limit to Congress's spending power is in the general welfare requirement. That what general welfare means, and was always understood to mean, is that Congress has to be spending for everyone's welfare, not for the welfare of particular places, particular people. And what I say is that that's incoherent, and that in a world where conservative judges are still the heirs of Bickel and that part of the New Deal settlement, it is impossible to adopt a judicially enforced doctrine of the general welfare, because what that requires is the court essentially to make nothing but a naked policy judgment, right? To say, well, this spending, because all spending is not to everybody in equal amounts, I guess unless you live in Alaska and are getting the dividend checks from the oil, everybody, which I believe is to everybody in equal amounts, most spending actually is to a particular purpose in a particular place, right? So federal education spending. Well, federal education spending is probably not federal spending that would have been anticipated by the framers, but is certainly well entrenched in our current system of institutions. And federal education spending, well, first of all, it's only on education, so it only helps teachers and kids in the first instance, although we think that it has benefits for everybody else. It also is allocated according to a formula that actually makes a lot depend on where you live, right? On poverty levels in the area where you live, for example. And there are certain education programs that are directed at particular kinds of education problems that only occur in certain regions. Now, is that spending for special narrow welfare, or is that spending for the general welfare? Well, it's hard to have any basis to say that it's spending for the special narrow welfare without saying that basically any spending is spending for the special narrow welfare, right? And why is that? Well, because there's lots of other spending going on that we think that when Congress adopts this law, although the money's going to particular people, we think that the benefits will be felt by everybody in general. Of course, anytime after Keynes, anytime you spend, you can plausibly say that this spending is going to help everybody generally. How do you decide what's in the special welfare, not the general welfare? Well, pretty much it's an analysis of whether you think this policy is really going to effectively work and be good for everybody. That sounds to a Bekelian conservative a lot like the pre-New Deal settlement era, when the courts seemed to be assessing the policy bases for legislation. So I think unlikely is an analytic matter to impose limits. The nexus relatedness requirement, this is it's a requirement that you probably read about not just in con law, not just about the spending clause in con law, but also unconstitutional conditions generally. You probably read about it in property class when a local government says, I'm going to give you this zoning variance, but only on the condition that you do these things, right? The doctrine, both as a matter of Fifth Amendment takings law and as a matter of most state laws, is that the city can give this variance on that condition only if the condition is somehow related to the reason why they get to deny the variance in the first place. right? The relatedness doctrine exists all over the place, and it's almost never a serious tool to limiting government power, and certainly in the area of federal spending, it's not. Well, why not? Well, I give a couple of analytic reasons again in the paper why it's not a serious limitation on federal power. Most of it boils down, though, to the Hamilton versus Madison again. In a world where Congress can spend for any purpose it wants and is not limited to spending for a single purpose, because I mean even giving money for education, so money for school lunches, actually has multiple purposes. It's not just to feed hungry kids to help them learn, it's also to support the producers of food and the economy that supports them. Right? In a world where Congress can spend for any reasons it wants and can spend for multiple reasons at a time, well then you can always say that one purpose of Congress's spending is to bribe the state into agreeing to whatever the condition is. Take Section 504 of the Rehabilitation Act, which says that when a state accepts federal funds, a state has to agree that it will not discriminate on the basis of disability and will provide reasonable accommodations to people with disabilities. Money that's given to states that has this condition attached to it may be money to build schools. It may be money to provide for various kinds of programming in prisons. It may be money for domestic violence assistance. It could be all kinds of different money. And the effort to say that the purpose of that money is just the one reason why, it's just the one name attached to the federal spending program doesn't make any sense. Why couldn't it be the case that Congress could just say, look, I'm going to give you, state, $10 million if you'll agree not to discriminate on the basis of disability. Okay, not 10 million, how about 100 million, right? Why is that not a proper purpose of Congress under the spending power? After Hamilton, of course it's a proper purpose, right? That's the Hamiltonian position. Congress can spend for whatever reason it wants. Congress can bribe the states. The whole purpose of conditional spending is to encourage the states to do things that they might not otherwise do, whether because they just don't want to do it but are accepting their reservation price for it, or instead because they want to do it but only if it costs less than it would actually cost to them, so you're giving them some encouragement to do it. But the whole purpose of conditional spending is to affect state behavior. And so therefore it doesn't make sense to say, well, we have to identify a single purpose and the exaction has to be related to that purpose. I think it's different from the property area where the nexus relatedness requirement is itself not a very serious limitation on government power, but is more serious because, of course, local governments can't regulate private property for any reason they want, but the federal government can give states money for whatever reasons it wants. Right. There have been various proposals to invigorate the nexus requirement. I think that they all basically founder on this same point. So there's an argument, the very prominent argument, probably the most prominent argument in the literature that's about nexus is by Professor Lynn Baker at the University of Texas, who says that, well, Congress should be able to give states money to reimburse them for programs that they're doing. So Congress can give states, 100% of what it costs to put cops on the street, or even 50% of what it costs to put cops on the street. But Congress can't say, I'm giving you money to put cops on the street on the condition that you have a death penalty, that you put in place the death penalty, because that's not related to the purpose of the expenditure. Right? Analytically, right, I think what Baker quite intelligently does is says this is not necessarily because federal spending has to have one purpose. She says the reason why I want to impose this rule is because otherwise it's a purely practical, pragmatic reason. Otherwise, majoritarian states will gang up on the holdout states. So Minnesota doesn't have the death penalty. Most states have the death penalty. She says, well, Minnesota might be getting some advantage as, well-educated, socially liberal people move to Minnesota because they don't want to live in Texas where there's a death penalty. It feels bad for them. Sorry about that, Mr. Young. But they might feel that they're getting an advantage from that, and Texas might be afraid of that. And Texas and Virginia and all the other states with death penalties might gang up on Minnesota and say, okay, we're going to effectively force you to get the death penalty. We're going to force you to get the death penalty by saying if you accept any federal funds for whatever reason, you have to have the death penalty. And she says this is the problem. It's particularly the problem, she says, because the federal government is taking away the states' money by taxing the people of all the states, effectively drying up their tax base. Right? And that's not an argument that's about sort of the analytic purity of a nexus requirement. What that's an argument about is we're afraid of this kind of collective behavior by states, and we have to have some rule. I don't think this is a very effective rule to deal with it. I don't think it's a very effective rule to deal with it, for one thing, because if you're a state like Minnesota, consider if you're a state like Minnesota in Professor Baker's world. You do not have a death penalty now, right? You don't really want to have a death penalty.
Now the federal government's taking away money that you could be taxing. Right? If that's Professor Baker's world, if the federal government's taking away money that you could be taxing, it has two possible offers to give you as Minnesota. One, it could give you back the money that you could be taxing if you adopt a death penalty. Or two, it could give you money that you ought to be taxing in order to help defray the costs of something you want to do anyway, if you adopt the death penalty. So it could give you money only if you adopt the death penalty and only to reimburse the cost of carrying out the death penalty, or it could give you money to do things you want to do anyway, but if you adopt the death penalty on the side. Which bargain do you want? If the federal government's taking away your money, well, I think there's a plausible argument anyway that the bargain you want is the bargain that Professor Baker says you should not be allowed to get, which is the bargain that it will pay you for something you want to do anyway if you're going to do the death penalty, right? Otherwise, a state that doesn't want to do the death penalty says, well, look, you're taking my money, and you're only giving it back to me not for any reason that I want, but just because you're trying to bribe me into getting the death penalty. And what does that do? Well, it means that if I really don't want to have the death penalty, and I probably don't want to have the death penalty, I'm Minnesota. Minnesota, they're very, quiet, peace-loving, and it's not the Vikings, it's the peace-loving Scandinavians, and they don't want the death penalty. And so they'll say, well, okay, fine, keep the money. But they're giving up something. They're giving up their tax basis. On the other hand, maybe they say, well, it's more important to me to have cops on the beat than it is not to have the death penalty, so I'll take that deal. At least that's an offer you'd be more willing to take, you'd more likely want to be offered than the offer will give you back your money to do something you don't want to do and you get nothing else from it. So I think that's one reason why her argument doesn't work very well. I think there are other reasons why the argument doesn't work very well. For one thing, I don't think it really is the federal government taking the state's money in any normative sense, right? The federal government has the power to tax, and it's a power that's supreme. And so as a normative matter, you can say it's the federal government's money. But even aside from that, federal taxation, all the public finance people tell us, federal taxation is not at a level that dries up state tax bases, actually. The thing that dries up state tax bases is interstate competition. Right? That states are going to have lower taxes generally. At least many states are going to say we want lower taxes because we want to attract people who want to pay lower taxes. And so in fact, the federal limits, the federal spending and federal taxation that supports federal spending is not the reason why states can't spend. So I don't think that's a very powerful limit. I don't think that's very likely to be adopted. Certainly hasn't ever been adopted. The last sort of direct limitation on Congress's spending power that comes up in the case law is coercion. Well, Congress can't make the state an offer that it can't refuse, an offer that's so great that the state can't refuse it. It would be coercive. Now, coercion is an argument. I mean, coercion is a concept you see all over the law, right? In every class I teach, whatever class I've ever taught, I spend like 3 weeks on coercion because coercion is everywhere in the law and the concept of coercion, and it's always very, very difficult to get a handle on. Certainly difficult to get a handle on in the situation where the state says, where the federal government says, or anybody says, look, I'll give you money if you do this, right? Well, if you gave me $10 million, I would probably do all kinds of embarrassing things right now. I would really like $10 million. Does that mean I'm coerced into doing it? It might be at a level that I say, well, gosh, it's so attractive. How could I possibly refuse? But is that an exercise of my choice, or is that making me unable to make a choice, right? This is in all standard coercion literature. You deal with this problem, and basically what most of the theorists have come down to is saying, well, coercion is something that happens when one or both halves of an offer are saying basically, we're going to take away from you something that we don't have a right to take away from you. So your money or your life, right? That's an offer I can't refuse. When Marlon Brando in the movie that I never saw said, I'm going to make him an offer that he can't refuse, right? I think it was Marlon Brando. I didn't actually see the movie. But when he said that, I've always assumed that meant we're going to tell him we're going to kill him, right? Not we're going to tell him we're going to give him $100 million if he does this, right? If I'm taking away from you something that you have a right to and saying, or I'm going to take something else, or you have to give me something that I don't have a right to, well, that is understood as coercion in sort of traditional offer threat analysis. But here, the idea that states have a right to federal largesse, that states have a right to the millions of dollars that they're getting, many millions of dollars that they're getting from the federal government, is very difficult to swallow in a world where there are no affirmative rights of the government, federal or state, or at least very few affirmative rights of the government. Certainly, affirmative rights to give people money are incredibly few and far between under our constitutional system. So difficult to say that it's coercion. So there are efforts to create a version of coercion that doesn't depend on the state having a baseline entitlement to a certain amount of federal money that's then being conditioned on the state doing something it doesn't otherwise want to do. But I think they all fall back on the same problem. They all fall back on the same problem of you have to have some understanding of what it is the federal government can't do. And so the most prominent one here is Professor Mitchell Berman at the University of Texas has a very interesting creative argument, but that basically falls back on a nexus requirement, that it's coercive to make an offer that you would withhold if you would withhold the offer for reasons, or withhold the benefits offered for reasons that have nothing to do with the reasons why you're offering the benefits in the first place. That's effectively a nexus argument and collapses for many of the same reasons. I think analytically all these reasons, all these various doctrines, there's a reason why in all the Federalist Revival you've seen very, very little attempt to really rein in the spending clause, because it's hard to come up with a doctrine that's tractable analytically. It's hard to come up with a doctrine that conservative judges are going to find palatable. I mean, coercion, if you think about the people in the law who are talking about coercion as, well, I'm coerced into doing something even though nobody's putting a gun to my head, right? I mean, who are they, right? It's the people who are singing the judicial version of that Joan Baez song, "Show Me a Prisoner," right? Which probably none of you have ever heard. But the idea is, well, it's all forces much greater than us that push us into doing things, and so we should be held not responsible, avoiding responsibility because of coercion that's systemic, right? That's the kind of argument you hear from judicial liberals, not that much anymore, but if you read Skelly Wright in your casebooks or whatever, you will see judicial liberals saying that, but conservatives don't often make that argument. It's a very difficult argument for conservatives to make. I think analytically it's tough. It's hard to come up with a rule. It's hard to come up with a style of argumentation that's actually consistent with what most conservative judges would want to do. And also, I said at the beginning, the second point is that there's a failure of motivation. Right, so the assumption is that as the Rehnquist Court and the Roberts Court hasn't really had much of an opportunity to continue this, to the extent it has had an opportunity, it's actually drawn a line and not gone any farther than the Rehnquist Court. But to the extent that the Rehnquist Court was trying to roll back federal power, was that because it wanted to roll back federal power for its own sake? Well, some, such as Professor Young, at some point would have said yes, and that's great. But in fact, as we see, because we have preemption doctrine in which a conservative court is very extensively ruling in favor of federal power over state power in an area where conservatives like federal power, tort suits, where state tort law tends to be relatively pro-plaintiff, at least more pro-plaintiff than a lot of federal preemptive statutes are. Because you have areas like that, you see actually it's not that the court has some principled opposition to federal power and wants things to be decided at the states. I tell everybody I see, the only person I know who has that kind of principled view about what the federal government should do and what the state government should do, and that the state government should do almost all of it, is Professor Young. That's the only person I know. I've never met another person. Everybody else who I've ever met in my extensive travels through the world is someone who wants the federal government to do things when the federal government's doing things they like, and wants the states to do things when the states are doing things they like. Right? That's basically it. Okay, it's not quite that extreme, but the only person who consistently holds to the principle that states should do most things most of the time is Professor Young. And so when you have this conservative limitation on Congress's power, right, it's not because they don't want Congress to be able to do things that preempt the states, that force the states to do things. And conservatives actually like various kinds of laws that force states to do things. They also like various laws that attach conditions to federal funding. So it's not a surprise that most of the unconstitutional conditions cases you see, cases that involve the same questions of nexus and coercion, as in this particular kind of unconstitutional conditions case, the kind of unconstitutional conditions case that involves the federal government giving money to states on conditions, right? Most of those cases are cases where you have relatively conservative limitations imposed on the acceptance of federal spending and federal welfare legislation. Russ versus Sullivan, federal government can finance contraception and can impose a limitation on them that they cannot even talk about abortion, right? That doesn't limit their First Amendment rights because they're willingly accepting the money. If you have a robust coercion doctrine in which a state which has taxing power can be coerced into not discriminating against people with disabilities because it's getting federal highway funds from the federal government, Well, then I think it's very difficult not to apply that same doctrine to at least make Russ versus Sullivan much more problematic for the federal government, right? Fair versus Rumsfeld, right? The federal government can say as a condition of giving money to universities, including many state universities, can say as a condition of giving money to universities, you have to provide equal access to military recruiters. Again, I mean, universities don't have the power to tax, so it would actually be a much more, and they rely very heavily on federal funds, so it's why they all knuckled under. If you say that a state can be coerced by withholding some funds because they're discriminating against people with disabilities, it's really, 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 really hard not to say that the universities are coerced, right? And you could go down the line, many, many of these cases. So I think my view is that there's no reason to expect that conservative judges have some view that they really want to rein in Congress's power to attach conditions to federal spending. In fact, it would be very problematic for lots of conservative programmatic interests. So what do I think is going to happen? I do think that there are limitations that the courts are likely to impose, further limitations the courts are likely to impose on the spending power, but I don't think they're the kind of direct limitations, Congress, you can't do this, that most people have talked about in the literature. I think they're much more likely to be indirect limitations that say, Congress, if you're going to do this, you have to do it in a particular way. Right, which mostly stem from this idea of fair notice, that the federal government has to give the states fair notice of the deal they're accepting, has to state in some specificity what the conditions are on federal funds, right? I think this is the doctrine that actually Chief Justice Rehnquist did enforce. It comes from Justice Rehnquist's opinion in the Pennhurst case way back. A lot of these cases are disability cases. Pennhurst is a case involving the Developmental Disabilities Assistance and Bill of Rights Act, which the court said doesn't actually provide rights that are enforceable, and it doesn't provide rights that are enforceable because, well, it states the rights in very general terms, so it doesn't very clearly state that a state that accepts these funds is going to be banned to comply with these rights and is going to be subject to suit for violating these rights. So the idea that there has to be clear notice of what is the condition on federal funds, and as I talk about in the paper, all the instances in which this notice principle has been pressed incredibly far. So you can say, totally plausible to say, and some judges have said it, that what notice requires is that every little detail of the application of the statute has to be set forth in the statute itself. Every little detail of how the condition will apply has to be set forth in the funding legislation, or else no lawsuit can lie to enforce the federal funding condition, right? So for example, the classic example of this is Justice White in his case, in his opinion, which was the controlling opinion for a time in the so-called Guardians case involving the application of disparate impact liability under Title VI of the Civil Rights Act. And what Justice White said is disparate impact liability, I mean, we know that states or whoever's covered can't adopt practices that have a significant disparate impact on women or racial minorities that is unjustified. We know that's what the disparate impact requirement requires. But what does that all mean? How do we specify that? There's no notice to states of how you specify that. So you can't sue a state for money damages for failing to comply with that provision because it's just too hard for a state to know. Right? It's sort of an application of the qualified immunity rule that usually applies only to individuals. And you see 4 justices of the Supreme Court, although not 5, in a couple of opinions in the late Rehnquist court, where Justice O'Connor abandoned the usual pro-state justices and went with the 4 who tend to vote in favor of broad federal power. You see 4 justices saying, in a couple of cases in the late Rehnquist court, that provisions of Title IX of the Education Amendments of 1972, which prohibit sex discrimination by educational programs that accept federal funds, cannot be used to enforce a prohibition on peer-to-peer sexual harassment because it's just hard to figure out when a government entity, when a school is going to be responsible for peer-to-peer sexual harassment. And you see a couple of justices say that the Individuals with Disabilities Education Act, which says sort of vaguely something about whether individuals should get related services, not school services, but related services that enable them to get into school, cannot be enforced to require those services because it's not totally clear, even though case law had made it clear in the past, right? And so what I suggest is the real action that's going to happen is not that anybody's going to impose any limits, any clear limits on what Congress can do. That what's going to happen is in the enforcement, in the implementation, in the application of spending statutes, what courts are going to do is more likely say, well, no, this isn't clear enough. There hasn't been clear enough notice. Go back to the drawing board, Congress, and because of the inertia of the legislative process, that'll be in many ways as good as saying, well, you can't do this, Congress, but it doesn't have the problem of being applied as precedent in cases like these unconstitutional conditions cases where we don't have suits for money damages, we don't have the same concern about clarity, clear notice. And certainly the court hasn't had that. I don't think I can at all unravel the unconstitutional conditions problem. In fact, my whole point is that it's really hard, if not impossible, to unravel the unconstitutional conditions problem. Everybody who has a set of views about just the Constitution generally is tripped up by the unconstitutional conditions problem, right? Conservatives are tripped up by the unconstitutional conditions problem because they believe in a negative Constitution. They believe that there aren't affirmative obligations imposed on people under the Constitution. Therefore, once you accept that there's a negative Constitution, no affirmative obligations, hard to say that the greater, denying funds entirely, doesn't include the lesser, denying funds unless the state agrees to some condition that they wouldn't otherwise have to do, right? For liberals, right, the difficulty is the opposite, because liberals, judicial liberals, at least in the modern age, tend to have a view that governmental largesse is really important, right? It's really important to get largesse from the government, but if that's right, and you have some kind of right or entitlement to the governmental largesse, then it's difficult to say that the government can deny you that largesse unless you comply with certain conditions. At least it requires some kind of analysis of the scope of those conditions, which is a kind of analysis that nobody's ever been able to come up with in any judicially tractable way. So I think the basic issue here is the unconstitutional conditions problem is impossible to solve, or at least nobody I know of has actually solved it. And therefore, doctrines that depend on a finding of an unconstitutional condition are doctrines that are not likely to have any traction in the courts. And that's why you see so many cases saying no unconstitutional condition here, and I think that's what's going to happen here. But I think to the extent that conservative judges want to limit federal spending power in a way that's targeted to the kinds of statutes they don't like, right, that what they'll do is require more and more notice and limit the private right of action to enforce spending conditions, which is something that usually is much more likely to be important in the kinds of statutes they don't like. All right, well, so that's what I have to say. I totally haven't solved the problem, and I wish I hadn't been set up to solve the problem because I couldn't do it. But that's what I have to say, and I'm interested in hearing any questions. Yeah.
You just finished by saying you think you could see the conservative justices using the notice requirement on a case-by-case basis. Do you see a concern or see them being concerned with trying to institutionalize that decision making, or do you think they just want to be able to reserve it so that on a one case-by-case basis? I guess, do they want judges 20 years from now to be able, are they more concerned in establishing the doctrine or in just solving the problems they see right now?
Well, I think the doctrine is out there. I mean, so the doctrine is out there that there has to be, clear notice of what exactly is really unclear. And so you have lots of cases defining it in various ways that, I spend probably too much time on in the paper. But, so the doctrine is out there. Now, the problem with like a clear notice rule or any interpretive strategy, right? Interpretive rule is the problem is you're applying this general rule to a whole lot of specifics that some aspect of is going to be different in every case. And so it's difficult to say in any binding way that because we didn't find enough notice in case X, that in case X prime we have to say there's not enough notice, right? These kind of interpretive rules have a hard time limiting the discretion of later courts. I mean, I tend to think courts can do pretty much what they want, but in any case, but that many judges, I'd say most judges, feel a need to try to make an argument that's plausible to most people in their community that their case, this case, is either consistent with the cases that came before, or there's a really good reason for departing from it. The thing about notice requirements and all these interpretive rules like that is that actually, it makes the judge's job really easy to say it's consistent with the other case because you can always point to some other aspect of some other case that was different. And so, yeah, I think that it's inherent in these kinds of requirements that they'll be applied essentially on a case-by-case basis. And so that's what I think they're likely to do. Yeah.
You talked about the conservative justices on the court kind of limiting things. And one of the things that that's been interesting, especially with Justice Roberts joining the court and kind of insisting, he's an umpire and blah, 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 is that they have very different approaches to exactly this type of sort of analytics, is it okay to articulate a broad principle, or should we be really, really narrowing? Do you see the different conservative justices approaching this differently?
Well, I mean, it's very interesting. So I mean, this is like the one development in the law that I actually take some credit for, because in Tennessee versus Lane and U.S. v. Georgia, which were two cases I litigated in the Supreme Court, what I said to everybody who was trying to defend the ADA was, look, there's this inconsistency between two aspects of what the then Rehnquist court was doing. One is they're striking down these congressional civil rights statutes on their face. They're saying statutes violate Congress's Section 5 power in the 14th Amendment on their face. They're not looking at particular applications. But you see this whole other set of cases where, I mean, it's people like Justice Scalia particularly, who are most insistent on saying that we can't consider the constitutionality of a statute on its face, Chief Justice Rehnquist says, unless all possible applications of it are unconstitutional, right? And so, I mean, the argument that I sort of had to win with my colleagues on all these cases was that we should make the argument that these statutes are constitutional as applied to particular cases, that the ADA as applied to this case is constitutional. And I think the court in those cases started to bring together its facial challenges versus as-applied challenge doctrine and its Section 5 doctrine. And you've seen actually in many, many other early Roberts Courts cases. I mean, U.S. v. Georgia is one, but in that term there are a couple others, and subsequently there have been a few more, where in general the court is very much reticent to strike down a statute on its face and saying, well, as-applied adjudication is what we do. I think that's here to stay, and I think actually, you know, the only justices in the conservative majority who ever were iffy about that, outside of the Section 5 cases where I think the problem was the issue was never raised. Nobody made the argument this is constitutional as applied until we got to Lane and Georgia. The only justices who were ever iffy about that were O'Connor and Kennedy, the only justices in the conservative majority. And Kennedy has now signed on very significantly to decisions in many cases that say we have to do this on an as-applied basis. So I think it's hard to see much difference now. I mean, you used to see, particularly in the 90s in the Rehnquist court, and in cases dealing with abortion, you would often see, particularly O'Connor, say, well, you know, abortion statutes could be struck down on their face because the undue burden test is necessarily something that looks to the face of the statute, to all the applications of the statute, not to a particular one. I don't think there's anybody, though, who takes that position consistently anymore who's in the conservative majority. Yeah.
I have a question about the coercion limitation that you were talking about, and specifically the Godfather example, I guess you could call it.
That's the movie.
I
really never saw that movie. I know everybody's seen that movie, so, but I assume he was talking about killing someone, I assume.
Yeah, well, I guess my understanding of what you were saying is that...
Answer my question.
Well, I mean, yeah.
Okay.
Yes,
go ahead. Sorry.
I guess my understanding of what you were saying is that it's not coercion unless you're taking away something from a state that a state had a right to have. So in essence, you're harming a state in some way. And I'm curious why that definition of coercion is so narrow, particularly with respect to the agent of harm. So for example, you know, if a person's hanging off a cliff or you know, near a cliff and you say, I'll push you if you don't do what I want, why is that meaningfully different from the person on the cliff than saying, if you don't do what I want, I'll let you fall off?
Absolutely, right. I'm sorry, go ahead.
Well, and I guess I'm a little surprised because my sense is that a liberal notion of coercion does tend to include some of these things on the penumbra. So, for example, we're talking about international aid. You know, my understanding is that liberals tend to be more likely to make arguments like, well, if a company opens up in this country, they really don't have a meaningful choice but to work at this company. Yep. Those sorts of arguments.
I totally agree with you, and that's exactly my point. So my point is that's a liberal kind of argument. So it tends to be conservatives, at least in our modern world, it's conservatives who have a lot at stake in the act-omission distinction. Right, it's conservatives who, I mean, this is just a tendency. In lots of individual cases, you're going to have differences. But in general, right, it's liberals who are making the Peter Singer argument that we have an obligation to provide for people around the world, and who are saying that, you know, the Occupational Safety and Health Act is justified to prevent coercion. Right, and it's the conservatives who are saying, well, actually, you get a risk premium for working in a riskier environment, and you know, yeah, maybe there are some things that people shouldn't have to put up with, but that's paternalism. That's not about coercion, right? So that's my point is exactly that it's an odd argument for conservatives to be making, and that's why you see Rehnquist consistently not make that argument. I mean, Rehnquist, who believes
above everyone else in the negative Constitution, right? Consistently avoiding making that argument, even voting to uphold things that you wouldn't expect that someone who cares about states' rights would uphold, like in South Dakota versus Dole, the condition on federal highway funds that you have to raise your drinking age to 21, right? I think a lot of that is precisely about, in our world, that's a liberal argument, not a conservative argument. So I think that's totally right. Yeah.
The liberals can make this work. I mean, presumably someday you're going to get the justices you want.
Well, that's why I didn't write the article that would be presented at the ACS conference about the spending clause for the next 300 years, because actually, I think this is an area where we all muddle through, right? Because my doctrine would not be. I mean, and this is not a paper about what I think the doctrine should be. It's about what I think is likely to happen.
But
my doctrine.
It's a question about what you think.
What's that?
It is a question about.
I know. No. So I'm saying, and my doctrine would be. I mean, actually, I think. I don't know how to do a tractable unconstitutional conditions doctrine. I mean, if I were a judge, I don't like greater includes the lesser. With both states and with private parties, I would probably be just a kind of Justice Stewart know it when I see it until I got some pattern. But I think it's interesting. I mean, why in South Dakota versus Dole, Justice Brennan is one of the two justices in dissent, along with Justice O'Connor. And I think the reason is because he believes the same thing. Yeah, we can't. There's no affirmative obligations under our Constitution. I might press on that a little bit, but that's an argument that I'm not going to win with anybody in the next 100 years. But if there are no affirmative obligations under our Constitution, well, maybe you're more sanguine from my perspective than I am. But if there are no affirmative obligations, then it's really hard to say that the state is, by conditioning the acceptance of funds on doing something you don't want to do, is violating your rights. Now, in some private law, in some areas involving private parties, it's easier for me, right? There are equality arguments, right? There are arguments about distribution. There are arguments about, First Amendment context about skewing the discourse, right? That are about the substantive constitutional rights at issue there. That I'm much more comfortable with, but you're right. I mean, and I could probably avoid this problem in a lot of cases just by saying no coercion here. And in the First Amendment case as well, it violates some substantive First Amendment value or violates some substantive 14th Amendment value. But that actually is an avoidance technique. It's not answering the question because I don't know. I don't really think anybody's come up with a good answer to that question. I think all the answers have been avoidance techniques. Yeah.
Two questions. It sounds like a great project, and it sounds like we come down pretty much the same way in terms of what's.
Yes. Well, your article says pretty much the same thing. I mean, so yeah.
But you say that.
Well, I say different stuff, but yeah. I don't know how to say that.
So two questions. The first is, how much money would it take for you to root for Duke in the Carolina game without feeling like you're being coerced? And the second question is.
But that's just about what my price is, okay? And so there are some things that just aren't worth it to me, right? I mean, so I don't think. I mean, you could take the entire endowment of Duke University. I mean, I might accept the entire endowment of Duke University in order to do harm to Duke University, but not because it's a benefit to me. So
you're helping the cause of Duke University today, so that cuts against it.
I just believe. I mean, I would have traveled to the Soviet Union,
But the more serious question is, are you?
All right.
Are you happy that the court accepted what you were pushing in Lane to the extent that you did, to the extent that it did, in light of what the court has recently done in the areas of abortion and voting rights? So are you responsible for Gonzalez against Carhart and Crawford against?
No, they were going to do it anyway. And so my point was we should get the benefit of that. I mean, if it's gonna hurt my friends most of the time, we're at least going to get the benefit most of the time. Some of the time, occasionally. No, I mean, so my view is that it was actually. It was a weird incongruity in the court's cases. And I think it was just because nobody really thought of it. I mean, that's my assumption. I haven't talked to anybody. I haven't talked to any of the justices about any of these cases. I don't know. But certainly reading the briefs, reading the argument transcripts, going to some of the arguments, nobody ever made the argument that, well, you should uphold this statute as applied here. Stevens does in his dissenting opinion a little bit in the Florida prepaid case, which involves the Patent Remedy Act. But it's sort of indirect, and no litigant ever made that argument. So I thought it was just incongruous. And the question was, how are they going to resolve it? Just a predictive question. And I think that, could they have said, City of Bernie Section 5 cases invalidate statutes on their face,
this is a general practice of constitutional adjudication, and we should bolsters the views of Justice O'Connor and the liberals in the abortion cases that we should consider these on their face, or instead whether they're going to say, oh, this is some weird different thing. It's just different. Section 5 is different. But it doesn't have anything to do with the fact that, of course, we evaluate abortion restrictions on an as-applied basis, which all the conservatives had been doing, I mean, except for O'Connor, had been saying over and over that that's what they wanted to do. And so I think they were going to do the same thing in Crawford in the election case, in the voter ID case, Crawford, and in Gonzales v. Carhart anyway. And it was just a way of kind of using that argument to an end that might not be a usually liberal end. So I don't feel terribly bad about it. But yeah, I mean, unless I were standing in front of them, I wouldn't make an argument that that's the way you should do constitutional adjudication. It's just what they do in other areas, and so I thought they should do it in this area too.
Well, thank you very much. This is excellent.
Well, thank you for having me, calling me a communist.